So, first of all, I want to introduce myself. My name is Jochen Reich. I'm a European and German patent attorney, and I hold a PhD in computer science, and I have my practice in Munich, Germany. So, today we're going to do patenting AI, what is required for reaching a grant being directed to AI patents, which is closely related to software patents, and I'm going to introduce some case law. As you see the overview slide now, first of all, we're going to do some motivation. Why is this webinar important for you? Why is it of interest? Then we're going to learn about the legal basis, the patent law, especially when it comes to software patents. We're going to talk a little bit about the procedure, how to apply for a patent, may it be a direct filing or a PCT regional phase entry. And then what is of most importance are the registration strategies, mainly the substantive aspects. And as we are, of course, dealing in general with patents, the geographical aspects here in Europe, because we have a very dedicated system of how you get protection in the single countries. And afterwards, we're gonna do a Q&A session where you are invited to share your questions, and we will discuss further. So further down the road, at some stage you want to earn some money. What typically is done in the field of AI is that a license is granted, or the patent is sold, or the portfolio is sold, as you can see on the right-hand side. Even if these inventions are used by software developers or vendors, they typically merely implement the upper layers of the AI application and use issues like the large language model using APIs. So typically, the whole AI system stack is too difficult and too large to be implemented by a single company. So what you can do is, if you want to earn money with the patents, you can give away a license, sell the patent, or if you have a own utilization, you will typically not be implementing the whole thing. What I'm also typically asked is there any need to provide a source code? Well, no, you don't even have to implement the technical teachings of your patent. So, according to this, there is also no need to provide the source code. The technical fields, which are mostly filed, is, as you see, computer technology, which is ranked number one. And then you see some related fields, like, for instance, digital communication on place three. So this is really a huge motivation for getting to know the issues with AI patents in Europe. And what you also can see from the number, is software patentable? Yes, of course, else we wouldn't have these large numbers in patent filings. So we will see a decision from the Supreme Court later on in Germany, which indeed ruled that software is patentable. So this makes perfect sense. So as you can see on this slide, the patent families which are dealing with NI or Gen NI are typically software related. Also, we see related fields such as life sciences, document management, business solutions, where the AI is not as such developed further, but merely used in those application domains. But typically, if you file an AI application, it is a software issue. So these numbers are really impressive, which is again a further motivation. And what is really amazing is that before European Patent Office, the top filing companies are not European companies. Maybe if you sum them up, you come to a similar number like the United States. But here from this slide, you see that as a single country, the United States are the most top filing patent applicants before European Patent Office. And this is very amazing, I think. So now we're gonna find out about the legal requirements, the legal basis for software patents and especially AI patents. So on the left-hand side, you see the German Patent Act, and on the right-hand side, the European Patent Convention. There's a lot of text, but I will refer basically to the bold writings. So as you can see, we have an exclusion from patentability regarding programs for computers, presentations of information. And as you also see on the slide, the German Patent Act and the European Patent Convention is more or less the same. They have more or less the same wording. And what is of special relevance for us is the last passage, respectively, which reads that a European patent application or European patent relates to such subject matter or activity as such, then it is excluded from patentability. So those two words are really the game changer regarding the patentability of software. And what is software as such, or what is, let's call it a technical software, we're going to find out on the next slides. So as I introduced before, software indeed is patentable either before the German Patent Office or the European Patent Office. We don't have any problems, but we have some requirements. And we will find out how this goes. Well, here of course, you are all experienced with patents. You have to have an invention. It has to be novel. It has to be inventive and commercial applicable. Regarding the invention as such, which has to be an invention of a technical field, we don't have any problems at this point because typically if a computer is involved, it is a technical software. So there is no problem with this aspect. So what is the problem here when it comes to inventiveness? The technical effect of the software is discussed. And as you will see on the following slides, the major issue of receiving a grant is regarding the inventiveness of the underlying invention. So they are not typically discussed at the beginning where it comes to is it an invention or not, but then even not during novelty the process step, but then when it comes to discussing inventiveness, we have to analyze the distinguishing features. This is the so-called problem solution approach, which is quite crucial before a European Patent Office. And there we have a very famous case law, namely the Comvic decision. And the Comvic decision, I'm going to explain in more detail to you. This is really the underlying procedure or the strategy how we examine AI patents or in general software patents. So what is AI in general? There's no AI as such. Of course, there's no definition. What is AI? Typically, this involves several related fields such as machine learning, computer vision, robotics, and so on. And so when we talk about patenting AI, we talk about all these related fields. And there's also always one question, is it technical or not? So typically we have hardware and software or software, but we might also have hardware and software. So the combination of both. So when we discuss the case law, we see pretty often that software is not claimed as such, but there is somehow any relation defined in the claims towards the hardware, towards the underlying components, which renders the software as such technical. But this is not required in any case. So we're going to see later on, I will introduce a software patent which comes with only basic features regarding the hardware. And this is very interesting. So what we were talking about when it comes to the inventive step question regarding technical features is the so-called convict approach. So this is really interesting for you to know how do we examine such claims. Well, in general, we have typically mixed type inventions. Mixed type means there are technical features and there are non-technical features. So how do we cope with that, and what is the procedure? According to the convict decision, on the right-hand side, you see the claim, which I will shortly summarize. The convict decision was mainly an application being directed towards a method in a digital cellular phone system. And the major issue here was that the subscriber or the user had like two identifiers. So one as a private user and one as a let's call it a business account. So the underlying problem of the application was how can we manage that one single person, let's call them user, receives two invoices and they're split regarding the private calls and the business calls. So as you can see, this is implemented in a cellular phone system. So this already sounds technical. But now, how do we deal with all the features? Like we have features related to the invoice, which is rather a business issue. And then we have a feature about the SIM card, the subscriber identification module. And what was ruled in this decision, which is really famous, is that regarding the inventiveness discussion, we merely use the technical features, and only their teaching is considered when assessing inventiveness. So this is very interesting. When it comes to assessing inventiveness, we leave the non-technical features out and merely use the technical features. So the problem solution approach, which you find on the left-hand side, is that we determine the closest prior art. We identify the distinguishing features, and then we try to discover the technical effect of those features, and then we make up the objective technical problem. And if the closest prior art being combined with one further prior art does not disclose or render the invention obvious, then you receive a grant. And then there's also afterwards the so-called could-would approach. The prior art, closest prior art, would the person skilled in the art really combine those two documents, or merely could the person skilled in the art combine those documents? If he would combine those, then it is obvious. If merely could could combine those documents, then it's might be leading to a grant. So, what is the quick learning of this slide? We have a very sophisticated approach regarding examining software patents, but we merely use the technical features of the claim, and the non-technical features are left out. So now that we have our application or the claim, how is the procedure? As you are a international audience, in-house drafting refers to my perspective. Typically, we get the application documents from the clients, so the in-house drafting does not apply, but rather the external drafting. Of course, when we get to draft the application, we have a discussion with the inventor, and there we urge the inventor to reveal all the technical features and try to introduce them in the claims. Typically, which is the last point on this slide, we receive the application documents ready to file. And what is the procedure here is that we can use the English applications before European Patent Office, before German Patent Office. You have to file a translation within 12 months from the filing date. So, do we need for original phase entry? Just the application number. And what I'm always very much aware of is to avoid undisclosed subject matter. So if we find out afterwards we need some further technical teachings or we have to rearrange the claim language or something, please be aware that European Patent Office is very strict regarding undisclosed subject matter. So in case anything is missing, if you find out you don't have enough technical teachings afterwards, you have to find them on a word by word basis in the description, almost word by word basis. So this is really, really what foreign applicants do not consider, that we have a clear, very decisive and specific disclosure of the amendments that we introduce. And if this requirement is not met, the application will be refused. So please be aware of that. So now with the registration of the software patents, now comes the very interesting part regarding AI patents. And as we were informed before, the AI patents pretty much rely on software patents. Of course, AI patents are software patents, and the whole case law regarding software patents is it can also be applied on AI patents. So what are the requirements for really providing a technical teaching, meaning provide technical features which can be used for the convict approach? There we have a case law collection from the European Patent Office, and I'm gonna show you right through the arrows on the left-hand side. Well, I'm gonna go down afterwards on the left-hand side. You learn that a further effect of a program has to be accomplished on a computer. So this means the typical launching of programs or execution of programs on computers is excluded from patentability. What you really need is a further effect. For instance, if you save memory or you use less computation time regarding CPU or GPU, this is a further effect of programs on a computer. So this is rendered technical and might lead to a grant. Is there a need for a direct link to a physical reality? There we have very specific case law teaching us that they did not see the requirement of a direct link with external physical reality in every case. So this leaves it open. It is not a general dedication that we do not need this physical link. But depending on the case, it might be enough that there is no direct link to physical reality, meaning, for instance, simulation software. So you can even get a grant if there is no direct link to the real world. So you might even get a grant for this one. And also, they ruled that a potential technical effect might be enough to reach a grant in case the technical consideration or the technical contribution is implied by the claim. So typically, this is if you have a technical effect hidden in the claim. You don't have to name the technical features directly if they are implied. This might be enough. So the technical effect may also be a virtual or calculated technical effect. So if the technical effect merely results in the reduction of data load or something, this might also be enough. This also, of course, depends on the underlying very specific case. So the technical effect does not have to be tangible, and the implementation of a function on a computer is also a further aspect. So the piece of information that was used or processed by a conventional computer is irrelevant. So the information, the underlying hardware, the information processing apparatus may be also a conventional computer in case the software delivers a technical effect. And regarding the last error, the computer implemented simulation methods, they are also uh, was also of the opinion that it is could be enough if the simulation has no technical link to real world hardware components. And they also ruled that also in this case, the convict approach applies, meaning that we also have to distinguish between technical and non-technical features, and then it depends on the claim wording, of course, on the technical features. So now we want to have a look at AI models and how they can be patented. So, of course, we don't have a single stack of AI application models. This is just an example. On the bottom, we have the physical layer, which is the hardware, the infrastructure, and on top we have the application layer, meaning the implementations which are based on further layers such as representation layer, the model layer, so the large language models, and then we have data processing model and the system layer with interfaces between those layers. So, from my point of view, it is possible to obtain a grant on every single layer of this stack, and I try to find some case law on some of those levels, which I'm gonna introduce now. First of all, this is a very exciting patent. It is rather a software patent, not directly linked to AI, but it is a good example on how a grant can be reached on the top layers of the stack. So we do not refer in this presentation to the ISO OZ stack, rather to the stack as I introduced before. But here you see a software patent, which is really has a broad scope of protection. You have only a method of presenting data that are stored in a data storage device of a data server to a user. So the user accessing the data server over a network, where in the process between accessing the server and presenting the data, at least one data path is used over which control data associated with the selection of data is sent, set at least one data path being unidirectional. So what you here have is a clear software patent, which was validated by a Supreme Court in Germany. Well, this is was led by my law firm against Microsoft. So this is our patent, which was challenged by Microsoft, and claim one as such is valid. And what you also see here, if you have a look at the technical features, when it comes to hardware, you have very, very little hardware features. You only have a data storage device, data server, which are commonly known concepts, of course. So with this little bit of hardware, we were able to receive a grant. So as you see from this claim, there's not much required for obtaining a software patent. And we are really proud this patent is really valid. So let's go to a further case law. I cannot always present the full claim. This would be time intense. So what we have here is a method of determining cardiac output, and which relies on a mathematical model. And furthermore, we have in the last line, we have the aid of an artificial neural network whose weighting values are determined by learning. So what we have here is, let's call it a generally known technical teaching. And what the inventor or the applicant tried in this case is that they used commonly known features and just added, well, we're going to apply some AI. Of course, this is not enough. The technical teaching has to go beyond the mere use of AI. So there's further examples how you can obtain a patent on AI. You can further develop the AI as such, or you have to find an application which provides a technical effect uh, going beyond what is known, and somehow the AI can be used, meaning that it somehow contributes to the technical character of the invention. So what was ruled in this decision, that it is not enough merely to provide an artificial neural network, but you have to disclose further features, so the claim as such becomes inventive. And I introduced this case law as I very often have clients that present such inventions, saying, well, of course, this is known, but what we are doing now is that we apply AI, and this is not enough. So commonly known features are not rendered inventive merely by using AI. But in case the AI or the way the AI is implemented contributes towards the technical character, you might get a grant. So the next slide is noise simulation in terms of noise reduction. And what was ruled here is that the simulation of a circuit subject to noise represents a sufficiently specific technical purpose. So this was also addressed in further case law, as I introduced before. So the simulation of noise, so to say, is technical enough. And in this sense, such simulation processes cannot be denied a technical defect simply because they do not yet encompass the physical end product. So again, here, what we see, as we heard before, there's 2 points. First of all, a simulation might be technical enough to be considered in the convict approach. And furthermore, it has not be directly linked to the physical end product. So this is very interesting, picking up 2 points of the former discussion of technical effects, of technical features. Then what we have here is a method for computerized classification of an unclassified text. So this rather refers to the lower or to the middle layers of the AI stack, where we have the large language model. And what was ruled in this decision is the following: since the mathematical algorithm does not contribute to the technical character of the claimed method, an inventive step can be present only in its technical implementation. So what is interesting, about this decision is that the first sentence, which I present here, since the mathematical algorithm does not contribute, it could be understood that in general, the mathematical algorithm might in general contribute to the technical effect. You can also read it in a way, namely that mathematical algorithms in this very specific case did not contribute to the technical character. But in my point of view, I would consider there's also mathematical algorithms that indeed apply to the technical effect of the underlying invention. And the next half sentence is an inventive step can be present only in its technical implementation. Well, this is clear. The technical implementation as such is a technical feature. And if you contribute in this manner, you will also receive a grant. So what we had here now is the substantive issues. We had the requirements. We had some case law on AI on different levels of the AI stack. And now regarding filing strategies, of course, we have you can enter the regional phase before European Patent Office, or you can do a direct filing, may it be either in Germany or in Europe. And what we have here, of course, I guess you all know the PCT procedure, so there's no need to discuss this further. But what might be interesting for you regarding the European perspective is the right-hand side. What happens if we enter the national phase? We say the regional phase before EPO, because according to European Patent Convention, we have several countries. And what happens is here you can have I would say two options which can be combined, which might form a third option, no matter how you name it. Currently, we have 18 EU member states of European patent conventions. And so once you receive a grant for a patent, you can obtain a unified protection before these 18 states with a single grant. And or this is interesting, and or you can validate up to 39 member states of the European Patent Convention. So what is this option is that you can pick single countries. For instance, you can pick Germany, France, UK. And what is also regarding these countries is of interest is that the EPC, the European Patent Convention, is not related to EU states. It can be according to the first option, but also countries like UK, which have left EU, can be validated. So just to summarize, you can have a uniform effect, meaning you have 18 member states with a uniform protection, meaning if the patent is challenged, the whole patent falls for any country among those 18 EU states. Or you can have independent up to 39 countries with independent patent protection, meaning if a patent is challenged and it is invalidated, it merely fails in this specific country. And what is the third option? You can combine those two options. So if you, for instance, pick the first approach with the uniform effect, you get like 18 countries in this example, not the UK as they have left EU, but you can combine the second approach and do a single validation of UK, and then you have also protection there. So the current UPC member states are as follows. Here you have the map. So with one single grant you can receive in the receive protection in these states, amongst others, Germany. And so when I summarize this issue, it depends how people or how companies choose their protection. If they want strong protection, they do a single country validation, which is more important, as you have to validate all the single countries which you pick. Or if you want to have broad protection regarding regional scope of protection, you pick the UPC, the first option. So this was just a general discussion of how the system goes. As we were discussing AI patents, of course, we were discussing the whole patent system from a European perspective as well. So this is it from my side. As I informed you before, we still have like 15 minutes for a Q&A session. So if you have any questions, feel free to ask